statement then follows. The accused is an adult male, 27 years of age, and charged with 3 counts. In count 1, it is alleged that he assaulted Karabo Mokoena on 27 March 2017 with the intent to do her grievous bodily harm. In count 2, that he killed
ummangalelwa sonke isikhathi komelwe umeli wakhe u-advocate Simelane amacala womathathu uye wawaphika wathi akanacala akanikezanga incazelo kodwa kuthe icala uma lokuliqhubeka kwase kuyavela-ke ukuthi kukhona ezinye izinto ezivelile lapho ubufakazi ummangalelwa ayewazivuma.
The state alleges in its summary of substantial facts that the accused and the deceased had a relationship, that he assaulted her on 27 March 2017 to such an extent that she had to be hospitalized, and that he killed her and disposed of her body by burning it. The state presented the following evidence. Stephanie Long, or Leong, testified that she and the deceased who had a relationship with the accused since October 2016 were friends. The deceased texted an invitation to her on her birthday on 26 March 2017, and she went to her apartment at Sandton Sky, which she shared with the accused. When she arrived, the deceased was alone, drunk, and the suitcases were packed. They took a taxi to Soweto and visited the club Icon. On seeing the accused there, the deceased got upset. On instructions of the accused, they took the deceased, who was quite drunk, to his car. She lay on the back seat, the accused drove, and the witness occupied the front passenger seat. On their way, the deceased woke up and kept on saying, "Let Sandile go to his girlfriends. He does not care for me." They stopped at KFC in Grayston Drive, where the accused got angry, turned around and grabbed the deceased by force. They subsequently went back to Sandton Sky, where they helped the deceased out of the car. The accused and the deceased started arguing and pushing each other. The accused pushed her with force and she fell, hit her head on the concrete floor, and the accused fell on top of her. The deceased cried, and the accused said, that he was going to fetch her bag. He no longer wanted the deceased there. He returned and put her suitcases at the gate, and he went to sit next to her. At that stage, they both requested her to go, and she left and went home.
Bafike bama endaweni lapha e-KFC ethengisa ukudla e-Gracetown Drive lapho ummangalelwa aye waqasuka khona wase ebamba umufi uStephanie wase ethi makayehlise umoya base bayasuka lapho bayahamba bonke bashayela baya e-St. Sky lapho kufike khona kwaba khona ukuhlelizisana phakathi kwamufi nommangalelwa bephushana umufi wagcina sewile eshaya ngekhanda phansi ummangalelwa wasewela phezu kwakhe emva lokho ummangalelwa waseyahamba ukuyolanda ke ikhwama ngoba akasamfuni lapha wabuya-ke ney'khwama zakhe wazibeka egeyithini base bahlala bonke phansi emva kwalokho bobabili umufi nommangalelwa batshela ufakazi ukuthi akunankinga angahamba.
The following day she continuously tried to get hold of the deceased, but to no avail. The accused called her between 16 and 18 hours and said that they must arrange a dinner to make the accused feel special. She replied that she will call him back, but never did.
Emva kwalokho ke ufakazi esekhaya ilanga elandelayo uye wazama ukuxhumana naye umufi kodwa akazangamthole ngey'nkathi zabo-4 kuya ku-6 ntambama ummangalelo wase-ke exhumana naye ufakazi emcela ukuthi kufanele ukuthi bahlangane kube nesidlo santambama ukuthi abayenze umufi ukuthi azizwe abalulekile wathi umfakazi uzobuya muva ummangalelo angasabuyi.
She again spoke to the deceased on the 30th. She could not exactly remember what had happened on the evening in question and inquired from the witness. She told her. The deceased also sent her 2 WhatsApp pictures, exhibits A1 and A2, and said that that is what the accused had done to her. The accused paid her hospital bill. She again saw the deceased the next day and told her to leave the accused. She noticed that her eye was bloodshot and blue and that she had bruises on her neck. She was afraid to go home because of her injuries. Because she could not stay at Sand and Sky, they booked into a hotel for the night. The next day, her sister and mother came to fetch her.
Ufakazi waseyamtshela wase emthumela ke iy'thombe ezimbili eziye zathathwa njengofakazi A1 no-A2 lapho eziboniswe khona naye azibonile ngomhlaka 31 lapho atshele khona umufi ukuthi kufanele ukuthi-ke athuthe laphayana uthi-ke ngaleso sikhathi umufi ube amehlo akhe ebebomvu futhi-ke abonisa nombala oblue lapho emehlweni round ubona uthi ngoba-ke bengakhona ukuhlala
On 28 April 2017 at 13:52, the deceased sent her a WhatsApp message and said that she wanted to see her. She replied on the 29th, but the message did not go through. That Sunday, she saw the accused at the Kong Club and asked him where the deceased was. He said that he did not see her nor spoken to her. She thereafter spoke to him frequently to inquire about the whereabouts of the deceased. On one occasion, he said that she was visiting secret hotels. She was convinced that the accused did not know where the deceased was and that he was cooperating in looking for her.
Lapho umufi ebecela khona ukuthi bahlangane kodwa ufakazi uye waphendula ngomhlaka 29 ku-April kodwa umlayezo ungene-ke kumufi wazama kulokhu ukuthi atholana naye kodwa azange akhona ukumthola wasehlangana nommangalelo endaweni yokuguquza okubizwa i-Kong lapho yewamthola khona-ke ukuthi ngabe uyazi ukuthi-ke umufi kodwa ummangalelwa wamazisa ukuthi akamazi wase ethi kuyena ummangalelwa umufi uthanda ukuvakashela amahhotela asemfihlane futhi baye baqhubeka baxhumana ufakazi nommangalelwa bezama ukuthola noma ummangalelwa ezenza ngathi uyasiza ekutholeni umufi.
On 10 May 2017, she went to the Sand and Sky, where she met the deceased mother, sister, the police, and other members of the community. While they waited for the accused, she saw video footage of the accused and the deceased entering the apartment. The accused left with different clothing, plastic bags, and a dustbin, which he took to his car, but the deceased did not leave again.
Ngomhlaka 10 kuMeyi 2017 ufakazi wayesemthithani anoma kamufi nodadewabo kamufi namaphoyisa namanye amalungu omphakathi bahlangane nommangalelwa endaweni yakhe yokuhlala lapho futhi eyobona khona-ke i-footage ethobuliwe lapho ebonise ummangalelwa engena ephuma kwenye indawo afake iy'mpahla ezingafani nalezi bekade azigqokile ephethe futhi namaplastiki yena.
When the accused arrived at Sand and Sky, they again asked him where the deceased was, and he said that he did not know. They went to his apartment, and she noticed that the carpet was wet. The accused said that he had cleaned it because it was moving. Bloodstains were noticed when the carpet was lifted. The police arrested the accused, and they moved to the Morningside police station, where she heard that the accused had confessed.
Lapho bamphile bambuza futhi ukuthi ngabe uyazi ukuthi umufi ummangalelwa wathi yena akamanzi base bangena endaweni yakhe ahlala kiyo semabangena lapho babona khona ukuthi imadi phansi imanzi kwase kubonakala futhi namabala wegazi lapho ummangalelwa yena uthe imadi leyo uyinile ngoba ubenza uthutha lapho kuleyo ndawo base amaphoyisa-ke ayambhalela bamusa eMorningside emaphoyiseni epolice station lapho ufakazi ezwe
The deceased was not suicidal and had a new zest for life after she and the accused broke up. She wanted to help abused women and wanted to set up an NGO.
Futhi befuna ukusiza abantu besimame abahlukunyeziwe efuna nokuvula indawo lapho labo bantu abafana abahlukumeziwe nabanganabazali abazophila kuyona.
During cross-examination, it was put to her that the accused arrived at his apartment on the 28th and discovered that the deceased had
uthi ummangalelwa yena ufike endlini yakhe ngomhlaka 28 kuMeyi 2017 wase ethola umufi evulele yena-ke wase uyathuka-ke wase ethatha umzimba eyowushisa.
Pontile Mokoena is the deceased sister. The deceased had a relationship with the accused, but they broke up before 27 March 2017, her birthday. The deceased called her the day after her birthday. She was in hospital. She went to visit her and found that she was injured as depicted on exhibits A1 and 2. They subsequently went to Sand and Sky to fetch her goods. On 27 April 2017, the deceased left her parental home and never returned. Her mother was worried about her, but the inquiries as to her whereabouts led to nothing. uyavuma ukuthi ummangalelwa nomufi bekade bathandana kodwa baye bahlukana ngomhlaka 27 kuMarch 2017 ngaphambi kosuku lakhe lokuzalwa uthi-ke baye bahlukana ngaphambi kosuku lakhe lokuzalwa ngomhlaka 27 March 2017 umufi ubekade esesibhedlela uye wayembona esibhedlela wamthola ukuthi wamthola elimele efana nale ithombe kunikezelwe ngazo phambili ufakazi A1 no-A2 ngomhlaka 27 ku-April 2014 umufi uye wahamba ekhaya lapho bahlala khona nabazali babo akazange aphinde abuye. Lokhu bomkhathaza kakhulu uma wakhe kodwa-ke izame zokumfuna ziye zayenziwa kodwa akazange atholakala isikhathi. She was present at Sand and Sky when the police arrested the accused, but she did not go up to his apartment. When they came down from his apartment, her mother asked him where Karabo was. Karabo is the deceased. He said that he did not know. She asked him whether he had killed her, and he said no. During cross-examination, she was asked whether she knew of other incidents where the accused assaulted the deceased. The hearsay evidence that was elicited in this matter, which is admissible evidence in the circumstances, was that the deceased had told her of such an assault when she found him with another woman in his hotel room. Puneng Tetwa, a friend of the deceased, testified that she saw incidents when the accused smashed the deceased's phone, when she denied him access to it, when he pushed her against the wall with his one hand, and when he threw her on the floor. Kiabetse Maseku is a sergeant at the Diepkloof police station at the Domestic Violence and Missing Persons section. The mother of the deceased came to report her missing on 10 May 2017 and gave her the accused's phone number. She phoned him and asked him when last he saw the deceased, to which he replied, 27 April at 16 hours. He said that she was at his apartment and that he accompanied her to catch a taxi. Later in the day, she and Captains Mslongu and Makadu met the deceased's mother and went to Sandton police station to inform them that she is investigating a missing persons case at Skye. They went to Skye and knocked on the accused's apartment door, but there was no answer. The manager phoned the accused and told him that the police were looking for him. In the meantime, the manager showed them video footage. They noticed the deceased and the accused come out of the lift and go into the accused's apartment on 28 April 2017 at 2 hours. At 21:57 it shows the accused going up with a dustbin. She did not see the deceased leaving again.
Uphoyisa uTyabeto na Captain Mhlongo noMakhado baye noma kaMufi baye bahamba baye eSandton police station lapho bafike babazisa khona ukuthi ke baphenya icala lomuntu ke olahlekile bacela ukuthi ke mabakhashwe eSandton Sky mabafike eSandton Sky umangalelwa abazange ke bamthola kwase ngaleso sikhathi besemlindile kwabuka ke ifootage le eveze umangalelwa noMufi bangena egumbini lakaMufi ngomhla ka-28 April isikhathi ku-2 ekseni 3 minutes to 10 ebusuku umangalelwa ubona engena endaweni yakhe akahlala kuyona ephethe udustbin.
The accused arrived between 21 and 22 hours. She told him that she was investigating the deceased's disappearance and asked permission to see his apartment, which he gave.
Umangalelwa yena ufike phakathi kwesikhathi umangalelwa wasemnikeza imvume wayosesha.
She found that the carpet in the apartment was wet and the deceased not there. He said that he was selling the apartment. She found something that looked like blood. She told him that she was arresting him for kidnapping and that he had the right to remain silent and a lawyer. He was then detained at Sandton police station. After she wrote down her statement, Captain Mslongo said that the accused said that he had killed the deceased.
Wabona umangalelwa waseukuthi yena indawo leya uyathutha kuyona wabona uphoyisa labona okunye kufana negazi waseke tshela ke umangalelwa ukuthi uyambopha umbophela icala lokuthumba futhi ke basibahamba baya esentini epolice station lapha eyovalelwa khona semva ukuthi aqede ukubhala istatement sakhe sokubopha umangalelwa wayesezwa uCaptain Mhlongo amtshela ukuthi umangalelwa uthe umbulele.
Bongikosi Mslongo is a captain in the South African Police Services. He was on duty on 10 May 2017 when he went to Sandton Sky with Sergeant Maseku looking for a missing person. He warned the accused of his right to silence. In the accused's apartment, he inquired about the bloodstains that the previous witness had testified about, but he said he knew nothing of it. He was arrested. At the police station, he again warned the accused of his right to silence and then asked him where Karabo was. He said that he did not know. He then freely and voluntarily said that he had killed her. The captain asked the accused with what, and he replied that he had burned her body. He went to fetch papers to write down what the accused had said, but when he returned, the accused changed his story.
Ubonginkosi Mhlongo ukapteni emaphoyiseni ukuthi ngomhlaka 10 kuMeyi 2017 ubekade semsebenzini lapho ke uyi-I watshelwa khona ukuthi ke makiwe esentini kuyofunana ke nomuntu ke olahlekile usengoba fika esentini kayinkathi ke umangalelwa eboshwa ukuthi umazisile amalungelo wakhe ubuya ngokomthetho futhi ke mabafika epolice station esentini wamazisa futhi ke ngamalungelo wakhe uthi uye wambuza umangalelwa ukuthi ngabe ukuphi umufi umangalela wathakamanzi kodwa ke kuthe emva kwalokho umangalelwa ngokukhululeka kwakhe nangokuzinikela kwakhe wase atshela uCaptain Mhlongo ukuthi ke umbulele umufi uma sekabuza ke uCaptain ukuthi kanjani wase uthi ushisa umzimba wakhe uCaptain uhamba athiyolanda amaphepha ukuthi uzobhala lokhu uma sekabuya umangalela useshintshe istory.
I did ask the parties earlier whether a trial within a trial was not called for to determine the admissibility of the admission, but they said no. During cross-examination, however, I gained the impression that the admissibility of the admission was being attacked, and I ordered that a trial within a trial be held to deal with the admissibility of the admission.
uCaptain Mhlongo ummeli kanye nombuso bathi cha kudingeki kodwa ithe emva ukuthi ke ummeli abuze uCaptain imibuzo kwase kuyabonakala ukuthi kufanele ukuthi ke kukhulwe elinye icala ngaphansi kwelinye kwase kwenziwa kanjani.
In the trial within a trial, he said that when he returned with papers to write down the admission, the accused said that he did not know what the captain was talking about. He denied that he wanted to make the statement, but did not deny killing her. He was alone when the accused said that he killed the deceased. He did tell Sergeant Maseko about the accused's admission. Before he asked the accused questions, he warned him of his right to remain silent and not answer questions. He said that the
wabhala leso statement kodwa engaphiki ukuthi ushilo ukuthi ukubulele umufi uCaptain uye wamtshela ke uCaptain uMaseko ukuthi ke umangalelwa utheni kodwa umangalela ubesengasafuni ukwenza istatement mayelana nalokho.
The accused testified in the trial within a trial that he was not warned of his right during a casual conversation with Captain Mslongo. He told Captain Mslongo that he did not know why he was there. To a question by the court, he replied that he did not know why he was arrested and taken to the police station. The captain said that he could see that he was a nice boy and that he should give him something small. Then he would let him go. He asked the captain what he was talking about. He replied that the accused must relax. He will see to it that he does not get into trouble and he will release him. He stepped out of the room, and when he came back, he asked him whether he had arranged something small for him. He said no.
ngenkathi ithula icala ngaphansi kwecala ukuthi-ke umangalelwa uthi-ke akaziswanga amalungelo wakhe ngoba ingxoxo yabo kuyingxoxo nje encanyana nje futhi bongasiyinto eziningi uCaptain futhi uthe umangalelwa uyabona ukuthi umangalelwa uwumfanyana nje okahle olungile futhi-ke amangamlungisela okuncanyana uzoyenza nje konke lokhu ukuthi-ke kudlule wasebuza-ke umangalelwa ukuthi kuzodlula kanjani wathi uCaptain hayi khululeka wena nje mongahlanganisa lokhu okuncanyana engikudingayo konke lokhu kuzodlula.
At this stage, he said that he did not tell Captain Mslongo that he had killed the deceased. During cross-examination, he said that Captain Mslongo was nice and polite and tried to assist him. He conceded that Captain Mslongo did not know that Karabo was dead during their interview. After arguments by the state and the defense, the court found that the admission was indeed made freely and voluntary. The reasons would follow after I have completed the summary of the evidence. Magaichi Mawete, a constable in the South African Police Services, went to Collar Drive after a call on 29 April 2017 and found the body of an indistinguishable person burned beyond recognition. She testified about what she overheard when Captain Mslongo and other officers had an interview with the accused, where he mentioned forex trading, power which he got in the business when he met the deceased, and the fact that they went to see Master. Captain Mslongo denied that he was present during such a discussion. The accused told her that the deceased committed suicide by stabbing herself in the neck.
Magwethe othi-ke yena ngomhlaka 29 ku-April 2017 uye waya e-College Drive endaweni lapho kutholakale khona isidumbu somuntu obekade angabonakali obekade ashe ngayo uthi-ke futhi uye wezwa e-police station-ke ephasijini-ke umangalelwa exoxa namanye amaphoyisa ngey'ndaba-ke ze-forex trading ekhuluma namandla okufanele ukuthi ube nawo kulelo bhizinisi ekhuluma futhi nangomaster uthi-ke uCaptain Mhlongo ubekade angamkhumbuli ngoba ubekade angamazi.
Rogers Mahundla is a captain in the South African Police Services. He interviewed the accused on 11 May 2017 at 5:30 and explained his right to him as contained in Exhibit C, whereafter the accused gave him the statement as contained in Exhibit C. The captain's evidence was unchallenged.
Captain Rogers Mahundla omunye wamaphoyisa uthi uye waba nengxoxo nomangalelwa ngomhlaka 11 kuMeyi 2017 isikhathi ku-5:30 uthi wamnikezela naye amalungelo wakhe njengomthetho ngaphambi kokuthi baxoxisane kwase kuwenziwa-ke i-statement esesabekwa njengomangalelwa.
A photo album containing photos which were extracted from video footage that was taken at the apartment of the accused was handed in as Exhibit D 1 to 54 and admitted in terms of Section 220 of the Criminal Procedure Act 51 of 1977. It was also formally admitted that Exhibits A1, 2, and 3 showed injuries that the deceased had sustained on 27 March 2017.
Kuye kwayenziwa futhi lapho-ke i-albhamu ekhishwe ku-footage kade ithwethuliwe lapho endaweni yokuhlala kammangalelwa. I-albhamu leyo ineyithombe kusuka ku-1 kuya ku-54. Leyo albhamu yavunywa kuya ngokomthetho wama-admissions of 220 ka-Act 51 ka-1977, futhi-ke neyithombe u-A1, 2 no-3 nazo ziye zabekwa njengofakazi wesehlakalo esenzeka ngomhlaka 27 kuMarch 2017 kumuntu.
Andre de Klerk is a colonel in the South African Police Services and not involved in the investigation of this case. He was requested to assist in the pointing out that the accused wanted to make. He met him at the Sandton police station and explained his rights to him, as contained in Exhibit E. Photos, Exhibits F2, 1 to 23, were taken during the pointing out. The key to the photos were handed in as Exhibit F1. The pointing out is described in Exhibit E, and he also made notes of the accused discussion with him during the pointing out.
Ngoba khona ummangalelwa obekade ayofuna ukuyokhomba uthi uye wachaza amalungelo kammangalelwa ngaphambi kokuthi umsebenzi wakhe. Kuye kwaba khona-ke ufakazi beyithombe eziyabekwa njengo-F1 nofakazi uye wabeka ku-Exhibit E, lapho-ke kuveza yonke into eyenzekile ngenkathi ummangalelwa naye beyokhomba.
The death register report, which the defense formally admitted was done on the remains of the deceased, determining the cause of death as uncertained at autopsy, was handed in as Exhibit G.
Kwaba khona futhi njengofakazi u-Exhibit G, lokho kubizwa phecelezi i-register kamufi eyenziwa lapho kuyona ku-register-ke kubhalwe ukuthi-ke inhloso noma imbangela yokushona komuntu ayaziwa.
Isaac Mabaso is a security supervisor at the Sandton Sky Apartments. There are 3 supervisors that work in shifts. He opened the accused apartment at his request on 29 April 2017 at 0:45 hours because he had locked himself out. He neither entered the apartment nor saw a lady surrounded by boxes of tablets.
Isaac Mabaso omunye supervisor abonogada abasebenza ke-SNT Sky uthi-ke babo-supervisor abathathu lapho ukuthi-ke uye wasiza ummangalelwa kucele ummangalela emcelile ngomhlaka 29 April 2017 ukuthi kayomvulela egumbini lakhe. Uthi-ke akazange abone owesimame alele lapho namapilisi phambi kwakhe.
Sergeant Cortella is the investigating officer, and he visited the Sandton Sky several times and perused the occurrence book for 2 months back, looking for an entry where the apartment of the accused was opened by the security and the deceased found on the floor with pills. He only found the entry of 29 April 2017, where Mr. Mabaso opened the door for the accused.
Sergeant Cortella omunye umphenyi kulecala-ke uthi-ke wavakashela e-SNT Sky kaningana esinye isikhathi lapho uye wacela-ke incwadi le ebizwa i-OB yenyanga ezimbili ukuthi-ke akhone ukuthola izehlakalo lapho ummangalelwa acele khona unogada lapho ukuthi bamvulele umnyango, kodwa uthole isehlakalo esisodwa somhlaka 29 ku-April 2017 lapho ummangalela acele ukuthi avulelwe umnyango, kodwa akukho lapho khona ukuthi-ke owesimame ubekadalele phansi namapilisi.
Happy Mapiri is also a security supervisor at Sandton Sky, but he never visited the apartment of the accused.
Happy waphili naye omunye osupervisor eSandton Sky uthi yena akaze avulele ummangalelwa umnyango lapho.
Lucky Nongoko is also a security supervisor at Sandton Sky. The accused approached him on 16 March 2017. On the way to the accused's apartment, they met Isaac, his relief, as they were about to change shifts. When they reached the accused's apartment, Isaac had to attend to another matter. They entered the apartment and found the deceased asleep. She apologized for not opening the door for the accused. He later asked Isaac to make an occurrence book entry about the incident.
Isaac wafanele ukuthi-ke ahambe ayobukana nesinye isehlakalo esenzekile khona lapho uma evula yena uthole umufi elele endlini wase uyaxolisa ukuthi angavuli umnyango kummangalelwa wathi ubekade elele engamuzi.
Tapiwa Majengura is a cleaner at Sandton Sky. On 29 April 2017, she found the ID and passport of Karabo in a dustbin on the 4th floor and gave it to Mr. Nongoko. That was the state's case. The accused elected not to testify in the main trial. It is common cause, firstly, as far as count 1 is concerned, that the accused and the deceased had an altercation on 27 March 2017, where they pushed each other, that she sustained no visible injuries during this altercation, and that she ultimately ended up in hospital with the injuries as shown in pictures exhibits A1 to 3, which the deceased sent to Mrs. Leong.
Lokhu kuyaziwa mayelana necala lokuqala lapho kuvele khona ukuthi ummangalelwa kanye nomufi ngomhla ka-27 kuMashi bayaba nokuphilizisana, kodwa-ke umufi azange avele ukulimala okubonakalayo, kodwa-ke ukugcina sesibhedlela ayinokulimala lokhu okuvezwe uthombe u-A1 kuya ku-3.
And 2, as far as count 2 is concerned, that the deceased entered the apartment of the accused alive on 28 April 2017 in the early hours of the morning at 2:48, as seen on Exhibit D, photos 9 and 10. That she left it dead in a dustbin on 28 April 2017 at around 2200 hours, as can be seen on Exhibit D 39, and further, that the accused used the dustbin to move her body to his car, and that he transported it to a location in Bramley where he used a tire and fuel to burn it beyond recognition on 28 April 2017, where it was discovered on 29 April 2017.
Ungene endlini kammangalelwa ngomhla ka-28 ku-April ekuseni ngamasa isikhathi ku-12:03 ekuseni ephila njengofakazi obuvezile ekuthombeni exhibit D, isithombe u-9 no-10, kodwa-ke wase ebonakala ephuma esephakathi kwedustbini kuya ngolithombe u-exhibit D39 ukuya phambili ebusuku. Ummangalelwa uphume-ke edonsa lesi dustbin ngomhla ka-28 waselihambisa kwenye indawo lapho afike khona washisela khona ngopetroli nevili lemoto. Umzimba wasotholakala ngomhla ka-29 ku-April 2017.
When it was discovered, it was unknown who the remains belonged to. Ultimately, the cause of death, according to Exhibit G, could not be determined because the body was burned beyond recognition.
kwagcina lapho futhi-ke kungatholakalanga ukuthi isizathu sokufa kwamufi kuyini ngoba umzimba ubushe ukuthi ungabonakali.
3, and as far as count 3 is concerned, that the accused did dispose of the body of the deceased.
Icala lesithathu khona kuvile futhi-ke ummangalelwa uye wawufihla umzimba kamufi ngokuhlawushisa.
The issues are, firstly, whether the accused assaulted the deceased with the intent to cause her grievous bodily harm. 2, whether the accused committed the act of killing her or whether she committed suicide. If it is found that she did commit suicide, then that would be the end of the matter as far as count 2 is concerned. If the court finds that she did not commit suicide, then the only other inference that the court would be able to draw is that the accused killed her.
Okukhona la ukuqala ukuthi ingabe-ke ummangalelwa uye wamshaya na umufi ngenhloso yokubanga ingozi emzimbeni wakhe. Okwesibili ukuthi ngabe ummangalelwa umbulele na umufi noma umufi uzibulele. Uma ngabe kutholakala ukuthi umufi uzibulele-ke lokho kuzothi ukuthi icala lizophelela lapho. Kodwa uma ngabe kutholakala ukuthi akusiko lokho, kusala nje ukuthi umufi ummangalelwa yena obulale umufi.
If the court finds that the accused did in fact kill the deceased, the court must then also determine whether his actions were unlawful and whether he had the intention to kill her.
Mangabe-ke kuthola inkundla ithola ukuthi-ke ummangalelwa umbulele umufi, inkosi enkantolo ifanele ukuthi-ke ithole ukuthi ingabe ube nenhloso yokukwenza lokhu noma-ke kunesizathu sokukwenza lokhu.
It was also a point of contention earlier that the accused had the intention to unlawfully defeat or obstruct the course of justice, but in argument, Mr. Semelane in fact admitted that he is guilty of count 3, in that he disposed of the body of the deceased in the attempt or in the act of defeating or obstructing the course of justice.
Ummangalela ube nenhloso yokuthi abalekele-ke ingalo yomthetho ukuthi-ke ashise umzimba kamufi, futhi-ke nomnumzane u-advocate Simelane uye wavuma ukuthi kulokhu ummangalelwa unecala ukuthi-ke azame ukubalekela isandla somthetho.
What was, however, not addressed is whether the accused succeeded in defeating or obstructing the course of justice or whether his action amounted to an attempt only.
Kodwa kungazange kuvezwe la umele ukuthi ngabe ummangalelwa yena uye waphumelela ekubalekeleni ingalo yomthetho noma-ke kuye kwadlulela kokunye.
I will return to that at a later stage.
Lapho sizobuyela emuva kwesikhathi.
There is no direct evidence that the accused assaulted her in the way depicted in Exhibits 1, A1 to 3, except hearsay evidence. Ms. Leong witnessed the deceased and the accused pushing each other around, where the deceased ended up with her head hitting the concrete floor on 26 March 2017. But this did not cause the injuries under discussion. He was not charged for that assault, but for the assault that took place on 27 March 2017. There was no direct evidence that he killed her. There is only circumstantial evidence and an admission that I will deal with later. The court has to evaluate these circumstances and determine whether it can draw an inference, which should be the only reasonable inference, that the accused in fact assaulted her and killed her.
Abukho ubufakazi obuveziwe ukuthi-ke kunezayithombo ukuthi ummangalelwa uyena obangele nokulimala kumufi. Kuwufakazi nje bezwa bethi lapho-ke Stephanie Leong athi-ke ubone isehlakalo lapho ummangalelwa besebenzisana khona nomufi umufi wase uyawa kodwa azange umangalela etheswe icala ngalesi sehlakalo kodwa utheswe icala ngesehlakalo senziwa ngomhlaka 27 kuMashi 2017 lapho umufi uye wagcina asesibhedlela futhi abukho ubufakazi obuvelile kahle hle ukuthi-ke ingabe umangalelwa uyena obulale umufi.
As far as count 1 is concerned, the hearsay evidence of Ms. Leong is that the deceased told her on 30 March, when she sent her exhibits A1 and 2, that the accused had done that to her. When Ms. Leong last saw her on 26 March 2017, she did not have those injuries. Ms. Mokwena's hearsay evidence is that when she visited the deceased in hospital after her birthday, she told her that the accused had assaulted her. This hearsay evidence, if accepted, is enough to prima facie prove that the accused had assaulted the deceased and that the injuries, as seen in exhibits A 1 to 3, were so severe that she was hospitalized. The question is whether the hearsay evidence is admissible.
umenzeni yena ugcina ukukhuluma noma ubona umufi ngomhlaka 26 kuMashi lokho akubona ey'thombeni kungakenzeki. Ufakazi bakaMsikwela bokuthi-ke umufi uye wamtshela ukuthi umangalelwa uyena oye wamshaya waze walala esibhedlela. Kuzoba ufakazi nabo bozwa bethi uma ngabe lo fakazi kutholakala ukuthi kuyiqiniso, lokho kuzosho ukuthi-ke umangalelwa uyena oye washaya waze walimaza-ke umufi. Kodwa-ke la into emqoka ukuthi kutholakale ukuthi-ke lo fakazi lobu bezwa bethi buzothathwa buyiqiniso futhi kube ufakazi noma buzoyekwa nje.
In terms of Section 3 of the Law of Evidence Amendment Act 45 of 1980, a court has a judicial discretion to admit hearsay evidence. In considering its admission, it is required of the court to have regard to certain guidelines. One, the nature of the proceedings. This is a criminal trial where the guilt of the accused has to be proved beyond reasonable doubt. 2, the nature of the evidence. This is hearsay evidence of what the deceased had informed Ms. Leong regarding her injuries and what she told her sister. The accused had taken responsibility for her injuries because he said in his statement, Exhibit C, that he punched her, pulled her out of the car, and, I quote, gave her my card to go to the hospital for check-up because she sustained injuries while we were fighting, and she was admitted for that night. End of quote.
Uye wanikeza ufakazi la bokuthi-ke umufi umtshela ukuthini futhi naye ummangalelwa ku-statement sakhe u-Exhibit C uye wavuma ukuthi-ke uye obangele lokhu kulimala kwabamufi nokuthi-ke amdonse amkhiphe emotweni amshaye nangencindi wasomnika ikhadi lakhe lebhanki futhi ahambe esibhedlela ayocilonga.
3, the purpose for which the evidence is tendered. The hearsay evidence is tendered for a compelling reason, namely to indicate that the accused had caused the injuries as depicted on Exhibits A1 and 2, and not for any illegitimate or doubtful reason. The deceased had passed away and cannot give this evidence. Had she been able to give such evidence, it would have been admissible.
Manje-ke umufi usesishiyile emhlabeni angeke aze akwazi ukuthi azonikeza ngofakazi bakhe. Uma ngabe bekhona ufakazi bakhe bebuzothathiwa, kodwa-ke ngoba akasekho kuzofanele ukuthi kubukisiswe kahle.
4. The probative value of the evidence. The hearsay evidence is intended to prove a fact in dispute, namely whether the accused caused the injuries in Exhibits A, 1 and 2. It was formally admitted that the deceased had sustained the injuries, which is visible on each other, that the deceased implicated the accused as the person who caused the injuries. Neither witness's evidence was disputed under cross-examination. As far as the evidence of Ms. Mokoena is concerned, it was elicited during cross-examination. Five, the reason why the evidence is not given by the person whose credibility the probative value of such evidence depends on. This is obvious. Six, any prejudice to a party which the admission of such evidence might entail. During cross-examination of the deceased's sister, the question was asked whether the deceased told her that the accused had assaulted her, to which she answered in the affirmative. Her answer was not disputed. This fact, and in view of the admissions mentioned in paragraph 2, there is, in my opinion, no prejudice to the accused in admitting the hearsay evidence under discussion. Seven, any other factor which should, in the opinion of the court, be taken into account. Ms. Leong testified about what the deceased had told her, and the evidence in this regard was not disputed. It was elicited from Ms. Mokoena that the deceased told her that the accused had assaulted her, and this was left at that. The accused remained silent after the closure of the state's case. After having considered all these requirements, I am of the opinion that the hearsay evidence should be admitted in the interest of justice, and it is so admitted. The court will now deal with the admissibility of the admission that the accused had made, or allegedly made, as he denied in evidence in the trial within the trial that he had made it. Captain Mslongo testified that he asked the accused what was in the dustbin, to which he replied, freely and voluntarily, that he had killed Karabo. I got the impression during the initial cross-examination that the admissibility of the admission was the issue, I subsequently ordered that the trial within the trial be held to determine the admissibility of the admission. During his evidence, however, the accused also denied that he had made such an admission. It therefore also had to be determined whether he made the admission, and if he did, whether it was admissible. I found that the admission had been made and that it was admissible. Section 219A of the Criminal Procedure Act, subsection 1, determines as follows: evidence of any admission made extrajudicially by any person in relation to the commission of an offence shall, if such admission does not constitute a confession of that offence, and it is proved to have been voluntarily made by that person, be admissible in evidence against him at criminal proceedings relating to that offence. The admission that is referred to here refers to an admission that is made outside of court, which is prejudicial to the accused. It also falls short of a confession. The onus is on the state to prove that the requirements have been met. Such an admission will be allowed in evidence if the state proves that the admission was made freely and voluntarily without compulsion. It should not have been induced by any promise or threat coming from a person in authority, which Captain Muslongo is. As far as the evidence of Captain Muslongo is concerned, he was, in my opinion, a calm, collected, and honest witness. He had no hesitation to admit his shortcomings as far as his knowledge of admissions and confessions are concerned. That does not disqualify him. He displayed no motive at all for wanting to falsely implicate the accused, and no motive for him to want to do that was put to him. In fact, the accused conceded that Captain Muslongo was polite towards him and wanted to assist him. It is therefore highly unlikely that the captain would have any motive to falsely implicate the accused.
khona ukuthi-ke ukhetheni uhlongo unesizathu sokuthi-ke akhulumele ummangalelwa amazwi.
If he wanted to do so, he could have done far better by concocting an admission or a confession, which he never did.
Mangabe befuna ukwenza lokho bezoyenza kangcono ukuthi futhi ahlanganise noma aqambe nje i-confession akhulumele ummangalelwa amanga kodwa akazange akwenze lokho.
According to him, he explained the accused's right to silence to him, whereafter he said that he killed the deceased.
Yangaye-ke uye wazisa-ke ummangalelwa ngamalungelo wakhe ukuthi angathula emva kwalokho-ke ummangalelwa yena wasevuma ukuthi umbulele umufi.
The accused refused that the admission be written down after he went to fetch paper.
Ummangalelwa wasewuyala ukuthi-ke lokho akakhulumile makubhalwe phansi emva kokuthi ukapteni ayolanda iphepha.
On the other hand, the accused was not an honest witness.
Kwesinye isandla ummangalelwa ngobufakazi ongathembekile.
He said that he was not aware why he was arrested and taken to the police station.
Uthe yena ubengazi ukuthi kungani eboshiwe ebizisweni police station.
This is, of course, not true, because he was asked several times about the whereabouts of Karabo.
Kodwa lokhu bongasilona iqiniso ngoba ubuzwe kaningi ngokuthi uKarabo ukuphi.
He was asked this before and after his arrest.
Ubuzwe lokhu ngaphambi nasemuva kokuthi aboshwe.
He knew from his own admission that he took a body and burned it beyond recognition. There is also the uncontested evidence of Sergeant Maseku. She testified that she informed the accused that he was arresting him for kidnapping.
Khona futhi nofakazi bakaSergeant Maseko okungaphikiswanga ukuthi umazisile ummangalelwa ukuthi umbophela icala lokuthumba.
This evidence is significant in the sense that at that stage the police was not aware that she was dead.
Lokhu ubufakazi bona kubalulekile ngoba ngaleso sikhathi amaphoyisa futhi bebengazi ukuthi uKarabo usehlonile.
If they knew, they would have arrested him for murder.
Mangabe besebazi bebazombophela icala lokubulala.
The court is satisfied that if all these factors are taken into account, the accused was well aware why he was arrested.
Kodwa inkantolo ejulisekile ukuthi mangabe zonke lezi zinto zihlanganiswa zonke ummangalelwa vezi kahle nje ukuthi kungani eboshiwe.
He further testified that Captain Muslongo said that if he gave him something small, he would let him go.
Kubeka futhi ummangalelwa wafakaza wathi uKapteni Mhlongo uthe uma ngabe amnika okuncanyana nje uzombhedela hamba.
He said that he asked the captain what he meant, to which he replied that he must relax, he will release him.
Yena uye wabuza uKapteni ukuthi ukuthini ngalokho uKapteni waphendula wathi khululeka ngizokukhipha.
He never said what the something small was that was referred to.
Azange asho ukuthi lokho okuncanyana bekade kukhulunywa ngakho kuyini.
I think that this piece of evidence also came as a surprise to Advocate Similane.
Ngiyacabanga futhi ukuthi nalo ubufakazi lobuncanyana buvele njengento emangazayo ku-Advocate Similane.
If it was his instructions to Advocate Similane, Advocate Similane would have put that version to the captain, which he did not do.
Mangabe u-Advocate Similane wazisiwe ngalokhu ngaphambilini lokhu ubezokubeka kuyena uKapteni kodwa azange akwenze lokho.
I'm therefore certain that his evidence in this regard is a recent fabrication.
Manje ngalokho mina nginesiqiniseko ukuthi lokho ufakazi lokho kuyinto eziqondele yona manje.
The accused did not testify that he was forced or threatened or promised anything to make the statement.
Ufakazi akazange umangalelwa akazange afakaze ukuthi uphocelele uthengisiwe noma uthuselwe ukuthi enze noma enikezele ngalofakazi enikezele ngabo.
The only point of contention was whether his right to remain silent and to say nothing was explained to him.
Inkinga nje la ukuthi ingabe ilungelo lakhe lokuthula angasho lutho uye wachazelwa lona na.
As he is not an honest witness, his allegation that it was not explained to him is rejected.
Manje ke njengofakazi ongathembekile ke nenkolo yokuthi ke azange yena aziswe leli lungelo angeke nje izithathe.
Captain Mhlongo was a satisfactory witness and the accused not. The court was therefore satisfied after the trial within the trial that the accused was aware of his rights to silence and what he told the captain was done freely and voluntarily. The accused in the trial within the trial also denied that he killed Karabo. During cross-examination, he said that Captain Mhlongo had made up the story. The uncontested evidence of Sergeant Maseko, however, is that Captain Mhlongo called her while he was in the company of the accused after his arrest. He told her that the accused had said that he killed the deceased. It seems that there was no response from the accused when this was said, because if there was, it would have been put in cross-examination to these witnesses. There is a more compelling fact for rejecting this denial by the accused. It is strike law that a previous in this case Captain Mhlongo is a recent fabrication. In other words, fabricated before his evidence. The uncontested evidence of Sergeant Maseko refutes the allegation that Captain Mhlongo's evidence in this regard is a recent fabrication. The accused conceded that Captain Mhlongo was not aware during their discussions that the deceased was dead. This was in any case evident because he was arrested for kidnapping and not murder. He replied to a question of the court that the police said that they were looking for Karabo. It is a fact that the police at that stage was only searching for the whereabouts of the missing Karabo. It is improbable and not consistent with the facts that he would fabricate and attribute such an admission to the accused where he was not even aware that the deceased was dead.
engezwakali futhi-ke enganangcono ukuthi-ke iphoyisa ukuthi-ke kungakhulunywa lokhu ngesikhathi amaphoyisa engazi ukwazi ukuthi useshonile.
The court is satisfied that the accused did say that he killed the deceased, which I have already found was said freely and without compulsion. The defense of the accused is that he did not kill the deceased. The question is, why would he admit that he did if he did not? Can this defense that the deceased committed suicide reasonably possibly be true? In his statement, Exhibit C, he mentions 3 attempts to suicide by the deceased. There is no other evidence except his unsworn statement regarding these attempts. The 3rd attempt, he states, was in March 2017. She allegedly drank pills and sent a text to his mother that she wanted to commit suicide. He tried to open his apartment but apparently could not, as he did not have a key, and the deceased, who was inside, did not respond. He got the security supervisor, whose name he did not mention, but who seems to be the witness, Lucky Ngoko, to open the door for him. The version of the accused is that they found the deceased inside. She was dizzy and pills were strewn all over the floor. She also left a suicide note, which she later destroyed. This statement was refuted by Mr. Ngoko. He testified that he did assist the accused to gain entry to his apartment on 16 March 2017. The accused said that his girlfriend was inside and that she did not answer to his knock. After he opened, they found the deceased sleeping under blankets in the bed. The accused asked her why she did not open. She apologized and said that she was fast asleep. He testified that he saw nothing sinister when they entered the apartment. She was not dizzy, and there were no boxes of pills strewn all over the floor or the bed. Mr. Ngoko was, in the court's opinion, also a satisfactory witness. He did not contradict his evidence and showed no or displayed no motive to want to falsely implicate the accused.
noma ummangalela ngobele inyama angayidlanga.
His evidence regarding the state that they found the room or the apartment in and the deceased lying under blankets, sleeping, was not really challenged in cross-examination.
Ufakazi bakhe umnumzane Ngoko ukuthi-ke bathole umufi evulelele ekamereni, yonke into ikahle, akuzange kuphikiswe kangako.
It was not put to him that the accused ever mentioned
Washo ukuthi-ke umufi uke wazama ukuzibulala.
if the deceased did try to commit suicide and he was locked out, that would have been the first thing that he would have mentioned to Mr. Ngoku.
Uma ngabe umufi uye wazama ukuzibulala yena akhiyelwa ngaphandle, into yokuqala bekummangalela bekade azoyisho umnumzane Ngoko.
It seems that the accused has told an untruth regarding this third attempt.
Kubonakala ngathi-ke ummangalelwa ukhulume-ke amanga nalokuzama kwesithathu.
The court is also certain that the same applies to the first two attempts which he mentioned in his statement.
Inkosi enkantolo iyacabanga ukuthi kuyinto futhi efanayo nakulawo amanye kulezi nkathi ezimbili.
His modus operandi was without doubt an attempt to paint a picture of the deceased who was prone to commit suicide to serve as corroboration for the defense that she had in fact committed suicide.
Lokhu kubonisa ukuthi-ke ummangalelwa bezama nje ukwakha isu lokuveza ukuthi-ke umufi uwumuntu okade azama ukuzibulala ukuze kubonise ukuthi lokhu akakushilo ukuthi umufi uzibulele kuhambisane nalokhu akakushilo.
According to Miss Leong and the deceased sister, she had everything to live for. She was not suicidal and had a new lust for life after her relationship with the accused broke up. She wanted to set up an NGO to help abused women and also visited an orphanage.
Kuya-ke ngoLeon naye udadewabo kamufi, umufi ube umuntu onoduzu nofuthufuthu lokuqala impilo yakhe kabusha, futhi efuna ukuvula indawo yabesifazane abahlukumezekile, futhi ubethanda-ke ukuvakashela indawo yey'ntandane.
Another reason which indicates that the accused is dishonest is conflicting instructions to his advocate.
Okunye futhi ukubonisa ukuthi ummangalelwa phakathi bakhe abuthembekile ukuthi-ke unikezela ummeli wakhe-ke imininingwane engahambelani.
Advocate Sumilane put it to Ms. Leong that the accused found the deceased had committed suicide when he returned to his apartment on the 28th.
Umnumzane Simelane uye wabeka kuLeon ukuthi-ke ummangalelwa uthe uthole umufi ezibulele umebuyela lapho ehlala khona ngomhlaka 28.
The undisputed evidence of Sergeant must saw the deceased on the 27th when he took her to catch a taxi.
Kodwa kungaphikiswanga kukaSergeant Maseko ukuthi-ke ummangalelwa utshele uSergeant Maseko ukuthi ugcine ukubona umufi ngomhlaka 27 ku-April nemkhapha ematekisini.
The accused listened to this conflicting versions while he sat in court.
Mangalelwa uhleli wamamela lokhu okungahambelani.
He did not try to get the attention of Advocate Sumilane, which he had done on many occasions during the trial.
Akazange azame ukuthi-ke abize-ke ummeli wakhe lokhu ekade akakwenzile iy'nkathi eziningana.
Prima facie, it points to the fact that the accused is not an honest witness, as the court has already found, and that his allegations are not true.
Fakazi iveza ukuthi-ke ummangalelwa ubufakazi obungahambelani obungasilo iqiniso.
The question remains whether, despite this finding about the 3 attempts, the deceased had not possibly committed suicide, although she might not have had the tendency to do so.
Umbuzo ohlela ukuthi emva kwazo zonke izehlakalo ezithathu ingabe umufi akazibulelanga na noma bengasi umuntu ongaveza lokho kuyena.
The body of the deceased was burned beyond recognition. It was not possible to make a finding as to the cause of death. It is therefore once again necessary to scrutinize the statement of the accused, Exhibit C.
Umzimba kamufi indlela ukuthi akatholakala ukuthi ingabe ubulalwe yini manje ke umqoka ukuthi ke sibuyele estatementini kaMangalelwa Exhibit C sisibukisise kahle.
According to his statement, he found that she had committed suicide when he entered the apartment. It is not his version that someone else killed her. It was obviously evident, if his evidence is to be accepted, that she had committed suicide. If this was so undoubtedly clear, the question is, why would he be afraid that he would be implicated in her death? There was nothing to be afraid of, because everyone would see what he saw and make the same conclusion as he did. He made no alarm or told anyone that she had committed suicide, which would be the first thing that any sound person would have done. The last thing a person would do if he finds a loved one who has committed suicide, which was according to his allegation evident, would be to try and exonerate yourself of a possible allegation that you caused the death. The accused caused the body of the deceased to be burned beyond recognition, and then tried to conceal that fact that she was dead. He got involved in a web of lies and told all that inquired about her whereabouts that he did not know, and that she visited secret hotels. What remains is for the court to consider whether this was a premeditated killing of the deceased. The accused went about very meticulously covering up his deed after the deceased was killed on 28 April 2017. Was. He said that he had not seen her or spoken to her. He apparently showed no emotion throughout, because if he had, that would have been put to the witnesses.
lokho kokubekwa ubufakazi.
Thereafter, she spoke to him frequently to inquire about the whereabouts of Karabo.
Emva kwalokho ubufakazi bekhulumisana nomangalela kaningana nje ukuthi kuzame ukuthi kutholakale noma ebuza ngoKarabo ukuthi
But it led to nothing.
kodwa lokho akusanga ndawo.
It was not disputed that the accused said on one occasion that she visited secret hotels, knowing full well that the deceased was already dead.
Lokho kuphikiswana ukuthi umangalela uthe umuntu uzevakashela amahhotela asezisakaleni elokhu azi kahle ukuseshonile.
He played his part so well that he brought her under the impression that he was also cooperating in the search for Karabo.
Yena wenze into yakhe kahle ngendlela ukuthi-ke ubonise uLeo ngathi-ke usebenzisana naye ekuzameni ukuthola uKarabo.
He also planned the disposal of her body carefully.
Futhi wasahlela futhi ngokulahla umzimba wakhe kahle.
He told Captain de Klerk that he took pool acid and a tire from his mother's house without anyone seeing him, which he pointed out in Exhibit F1.
Utshele noColonel de Klerk ukuthi-ke uthathe ivili lemoto kanye nepool acid emzini kama wakhe kungekho umuntu ombonayo futhi wasuyahamba uyegaraji uyothenga nepetrol.
Bought petrol at a filling station, which he also pointed out, and then at night, just after 22 hours, according to Exhibit D39, carted her body in a dustbin to his car to dispose of it.
Thengile upetrol kule garaji waseke ehamba ebusuku ngabo-10 buya ngofakazi D39 lahla umzimba wakhe wawushisa.
All these actions have, however, taken place ex post facto.
Konke lokhu kwenzeke emva kokuthi isehlakalo senze. Umangalela ngabe asosile ukubulala.
Without more concrete evidence about any premeditation, the only reasonable inference is not that he had planned beforehand to kill the deceased.
Ngaphandle nje kofakazi okuningi okuvezayo lokhu khona okushoyo ukuthi akakuhlelanga isikhathi esiningi ngaphambilini.
He might also have acted in that way to conceal what he had done.
Ngabe enze lokho ngokufihla lokho akakwenzile.
The state asked the court to accept the evidence of a single witness, Constable Malwete, of what the accused had told her regarding rituals and the person master, about killing each other if things did not go right.
Umbuso-ke uye wabuza ngofakazi oyedwa okhohlakulayo akakhulumile lokho akakhulumile kwenziwa-ke kwemisebenzi yamathwazi nomasa lokhu ukuthi-ke nofakazi lokhu ngabe bufakazi ophathekayo.
What the court in such a case would actually do is to admit evidence of a premeditated murder.
Manje-ke inkosinkantolo ngalo fakazi ufana naloku into engayenza nje ukuthi-ke ithathe le fakazi njengofakazi bokubulala okuhleliwe.
She is, however, a constable, and her evidence does not meet the requirements of Section 217(1) of the Criminal Procedure Act.
Kodwa-ke yena ukhonstabuli manje-ke lokhu-ke ufakazi bakhe abuhambisani nemithetho yaka-Section 217 ye-Criminal Procedure Act.
Her evidence is therefore impermissible.
Manje-ke lobo bufakazi lobo akuthatheki kahle.
As far as count 3 is concerned, the crime is committed when someone unlawfully and intentionally engages in conduct which defeats or obstructs the course of justice. CS versus Burger, 1975, 2 SA 601C at 611 to 622.
Icala lesithathu-ke icala leli umuntu aqhubeka noma ngabe eba nesenzo akasenzayo ukuze abalekele ingalo yomthetho lokhu kuboniswa uma kufika laphaya ku-Acts verses 1975.
It is common cause, as the court has already said, that the accused disposed of the body of the deceased by burning it beyond recognition. The accused had, in all likelihood, already killed her in his apartment, if one looks at the photos and how he carted the body in a dustbin from her apartment to his vehicle. There is no doubt that his intention was to cover up the fact that she was dead and the cause of her death. By burning the body of the deceased beyond recognition, he attempted to conceal the cause of her death and prevented that evidence from being placed before court. The court is, however, able, albeit by inference, to determine that the cause of her death was through stabbing by the accused. She could have died of nothing else. His actions did not succeed to effectively defeat or obstruct the cause of justice. He did, however, attempt to do so. Her remains were ultimately found, and he was brought to book. Prima facie, the following is evident from the state's version. Count 1, that the accused assaulted the deceased on the date mentioned in the charge sheet with the intent to cause her grievous bodily harm. The seriousness of her injuries was clear from the fact that she had to be hospitalized, therefore. 2, that the deceased did not have a tendency to commit suicide, did not attempt it, did not commit it, and that the accused killed her. 3, there was no possible justification for such killing. The defense did not plead any justification, and one can come to no other conclusion but that it was unlawful. As far as his intent is concerned, one cannot look into the mind of the accused to determine whether he had the intention to kill her or not. One must look at the surrounding circumstances and try and establish from that whether he had the intention to kill her. He went about very meticulously to clean up after he killed her, except for a blood stain that was discovered. She was stabbed with a knife, and that statement by the accused is true because there is no other explanation for her death.
ngoba azikho enye into ephikisana nalokho.
except the one by the accused that the death was caused by a knife wound.
Buyaveza ukuthi ufakazi lokho obona kuphela obukhona inkantolo efanele ukuthi ibuke.
The court is satisfied that the state has proved its case against the accused beyond reasonable doubt.
Inkantolo iqinisekile-ke ukuthi umbuso uveze ngakho konke emandleni wabo ukuthi uveze ukuthi ummangalelwa
He's found guilty of the following: count 1, as charged.
ummangalelwa-ke uthola necala ngandlela le elandelayo icala lokuqala unecala
Count 2, of murder.
icala lesibili lokubulala
And count 3, guilty of attempt to defeat or obstruct the cause of justice.
icala lesithathu elokuzama ukubalekela indalo yomthetho.
Will you call me when you're ready? Are you ready for the the sentence proceedings? Must you establish